Hello YouTubers, Joe Kersey here on June 30th, 2015 at 11:30 in the morning, Eastern Daylight Time. I'm going to do the third in my series. This is the third and final video in the series of remarks on the OBERGEFELL versus Hodges decision, starting with the majority opinion in the first video, the video yesterday in which I covered Chief Justice Roberts' dissent, and then today I'm going to deal with Justice Scalia's dissent, and this is the most fun of the four dissents, and I will conclude the series at the end of this video. We'll just get right into it. I will say that Justice Scalia is known for being the most, well, he's considered to be, he and Clarence Thomas are considered to be the most conservative, quote, conservative justices on the court. And by that, it's not so much, politically conservative or right-wing conservative, but conservative in the sense of trying to adhere as closely as possible to the original meaning of the Constitution, whether it was the original unamended document before the Bill of Rights was attached, or the original, the language of the amendments as they were written. What did the language mean when they were written? Not as we often read it now, or some people can read it now. Anybody that's ever, picked up the King James Bible and read it knows that the meanings of the words as used in the early 17th century have shifted over time. Not all of them, but a number of them. The most obvious example being the word prevent. The prayer, prevent us, O Lord. When people hear that for the first time today, take that to mean that the Lord is going to stop us from doing something. But in the 17th century, prevent meant go before. Vent meaning, it's really a negative way of saying come. Vent is a derivative of the various Latin and Norman French words come, or to travel, and then pre meaning going before. So prevent us, O Lord, means go before us into what's going to happen and take care of us. But there are many other shifts in usage in the King James Bible, and there are many other shifts in usage from the late 18th century language in the Constitution, and indeed sometimes in the mid 19th century language of some of the later amendments. Once we get up to around the 16th and 17th amendments, that's into the early 20th century language, that those meanings have tended to stay constant. So with that little bit of background, we'll read a few excerpts here from Justice Scalia. When the 14th Amendment was ratified in 1868, every state limited marriage to one man and one woman, and no one doubted the constitutionality of doing so. That resolves these cases. Now that's a fairly definitive statement right there. That resolves these cases. Meaning, nobody had to write anything else. Well, that didn't stop him from writing some more. When it comes to determining the meaning of a vague constitutional provision such as due process of law or equal protection of the laws, it is unquestionable that the people who ratified that provision did not understand it to prohibit a practice that remained both universal and uncontroversial in the years after ratification. Now, he raises an excellent point in the sense of vague determining the meaning of a vague constitutional provision such as due process of law or equal protection of the laws. And they are vague. Those two phrases have been debated endlessly since the 14th Amendment was written, probably, let alone ratified, when it was being drafted. You can essentially make these lines mean anything you want them to read if you want to really twist them a lot. Equal protection, equal protection of the laws could mean the equal part right there gets you into a can of worms. And protection of the law. Suppose the laws actually aren't protecting you. Suppose they're actually keeping you from exercising liberty, which is one of the points of the majority opinion, actually. And then due process, the great God process looms over us all here in terms of the policy and procedure mentality that dominates today's society. But what about the substance? Due process of law, they ought to really say, due process of law that results in substantive justice. Now that would have added another little layer of controversy to that amendment, wouldn't it? Maybe they need to amend the 14th Amendment. Not seriously suggesting that, but anyway, it is unquestionable the people who ratified that provision did not understand it to prohibit a practice that remained both universal and uncontroversial in the years after ratification. We have no basis for striking down a practice that is not expressly prohibited by the 14th Amendment's text and that bears the endorsement of a long tradition of open, widespread, and unchallenged use dating back to the amendment's ratification. Since there is no doubt whatever that the people never decided to prohibit the limitation of marriage to opposite-sex couples, the public debate over same-sex marriage must be allowed to continue. Now that's very interesting. He actually makes two statements in that one statement. He advocates not, establishing a policy by judicial fiat that wasn't extant at the time of the 14th Amendment. And since the 14th Amendment deals neither positively nor negatively with the issue of marriage at all, he says the matter remains in the hands of the public by the democratic process. Well, he'll say that later, but that's what he's driving at. And that, again, that gets back to the original meaning debate. And the other really famous phrase in that whole controversy over original meaning is Justice Douglas's, who was on the court back in the 50s and into the 60s, and served well into his 90s. He said that, the Constitution contains many penumbras, Many rights are hidden under penumbras in the Constitution. Well, maybe not quite to the extent he liked to say, but perhaps certainly there's some implied rights there, I would say. Moving on. And here's where it gets fun. Here's where his language, and the way he characterizes things are just so much fun, whether you agree with them or not. Buried beneath the mummeries and straining to be memorable passages of the opinion is a candid and startling assertion. No matter what it was the people ratified, the 14th Amendment protects those rights that the judiciary in its reasoned judgment thinks the 14th Amendment ought to protect. That is because, the generations that wrote and ratified the Bill of Rights and 14th Amendment, did not to presume to know the extent of freedom in all of its dimensions. Well, just before I go on to his next qualifying phrase, they obviously didn't. They kept slavery. They didn't get rid of slavery in the original Constitution, which they could have done, although that would have probably resulted in the original Constitution never happening. Yeah, of course they didn't know the extent of human freedom in all of its dimensions. Then he goes on, one would think that sentence would continue, and therefore they provided for a means by which the people could amend the Constitution. Okay? Or perhaps, and therefore they left the creation of additional liberty, such as the freedom to marry someone of the same sex, to the people through the never-ending process of legislation. But no. Now, I like the never-ending process of legislation, and that's of course one of the unspoken issues is how long is this going to go on? You have a situation where a number of states have legislated same-sex marriage. You have then an additional group of states where the appeals courts decisions have essentially said there must be same-sex marriage, or same-sex marriage is implied enough that other states have started issuing same-sex marriage, licenses to same-sex couples. And then you have, that gets you up to around 31, if I'm right on that. And then, even though that's not 31, haven't legislated that. And then the residual things, they're just engaged in, they've either flat out prohibited it and there's no controversy about that in that state. Or, as in the case with the Ohio, Tennessee, Kentucky, the three, in Michigan, the four states in the sixth appellate circuit, and that appeals court decision was at odds with the other appeals court's decisions. There's a controversy. How long are you going to let this go on? How long are you going to keep kicking it back to the legislatures? Well, or referenda. In general, I think most of this stuff should be left to states. Pretty much anything should be left to the states that isn't, expressly taken from them in the Constitution. But again, then you get into these gray areas, these areas of litigious contention that haven't been hardcore, clear-cut dealt with. And so then it becomes a judgment call, ultimately. Moving on with Justice Scalia. Except as limited by a constitutional prohibition agreed to by the people, the states are free to adopt whatever laws they like, even those that offend the esteemed justice's reasoned judgment. Free to adopt whatever the laws they like. Now that's a fairly sweeping statement. A system of government that makes the people subordinate to a committee of 9 unelected lawyers does not deserve to be called a democracy. Judges are selected precisely for their skill as lawyers. Whether they reflect the policy views of a particular constituency or not should not be relevant. Well, this gets you back to Marbury versus Madison in terms of the first Supreme Court case that established judicial review. Before then, the Supreme Court hadn't presumed to say an action was unconstitutional, and then you had the Marbury versus Madison. That was a very controversial at the time, controversial decision at the time. As it turned out, it wasn't obeyed. It was defied. It ultimately was rendered moot by something else that happened afterwards. But this was not. At the time, they said this wasn't explicitly written into the Constitution that the Supreme Court can do this, and it wasn't. But the argument that was made was, in order for things to work, they have to do it. If they don't do it, none of this this balancing idea that was described so eloquently in the Federalist Papers works. So, I think sometimes you have to be careful with what, say judges can and can't do. Although they generally need to sit on their hands as much as possible. And he goes on. And to allow the policy question of same-sex marriage to be considered and resolved by a select, patrician, highly unrepresentative panel of 9 is to violate a principle even more fundamental than no taxation without representation. He says, no social transformation without representation. That's a great phrase. No social transformation without representation. Think about it. But what really astounds is the hubris reflected in today's judicial push. And now we get to the real fun. The opinion is couched in a style that is as pretentious as its content is egotistic. It is one thing for separate concurring or dissenting opinions to contain extravagances, even silly extravagances, of thought and expression. It is something else for the official opinion of the court to do so. Of course, the opinion's showy profundities are often profoundly incoherent. And actually, he does find a few sentences that are pretty off the wall. He quotes, "The nature of marriage is that, through its enduring bond, two persons together can find other freedoms, such as expression, intimacy, and spirituality." He remarks, "Really, whoever thought that intimacy and spirituality, whatever that means, were freedoms? And if intimacy is, one would think freedom of intimacy is abridged rather than expanded by marriage. Ask the nearest hippie." He goes on, "Expression, sure enough, is a freedom, but anyone in a long-lasting marriage will attest that that happy state constricts rather than expands what one can prudently say." Rights, we are told, can arise from a better informed understanding of how constitutional imperatives define a liberty that remains urgent in our own era. He critiques, How can a better informed understanding of how constitutional imperatives, whatever that means, define, whatever that means, an urgent liberty, never mind, give birth to a right? And we are told that, in any particular case, either the Equal Protection or Due Process Clause may be thought to capture the essence of a right in a more accurate and comprehensive way than the other, even as the two clauses may converge in the identification and definition of the right. Well, that is a very unspecified and generalized formulation of the underlying intention behind the majority opinion. it could have been expressed a little more specifically, clearly, I think, as he's pointing out in his wonderfully ironic and sarcastic way. He says, "What say? What possible essence does substantive due process capture in an accurate and comprehensive way? It stands for nothing whatever except those freedoms and entitlements that this court really likes. And the Equal Protection Clause as employed today identifies nothing except a difference in treatment that this court really dislikes. Hardly a distillation of essence. If the opinion is correct that the two clauses converge in the identification and definition of a right, that is only because the majority's likes and dislikes are predictably compatible." Well, and again, this gets down to the, you have two worldviews. You have two different worldviews. The worldview that prevailed probably should have, could have been done so a bit more elegantly, but two different worldviews. I could go on, he says. "The world does not expect logic and precision in poetry or inspirational pop philosophy. It does demand them in law. The stuff contained in today's opinion has to diminish this court's reputation for clear thinking and sober analysis." Well, it certainly, by his reading, certainly might diminish the reputation for clear expression in some parts of that. That's a legitimate criticism. And now I want to read you this wonderful footnote he put, and then I'll be gone. And in a footnote, "If, even as the price to be paid for a fifth vote, I ever joined an opinion for the court that began, 'The Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity, I would hide my head in a bag. The Supreme Court of the United States has descended from the disciplined legal reasoning of John Marshall and Joseph Story to the mystical aphorisms of the fortune cookie.'" And on that note, I'm going to say I've dealt as much as I'm going to with OBERGEFELL. Needless to say, I agree with the opinion. The majority opinion. Well, I don't know, not needless to say at all, actually, but I agree with the majority opinion. However, perhaps unprecisely it might have been expressed in some parts of it without proper definitions and so forth. But again, it does leave us open to a number of conflicts analogous to the continuing conflicts over the abortion situation, and then conflicts over how far churches can advocate against this without being considered to unnecessarily stray into political advocacy. Certainly they can't advocate for candidates. On the other hand, for particular parties, but they can advocate certain positions. My Lord, churches take positions on social issues all the time, and that doesn't imperil their tax status. So that remains to be seen how that gets, thrashed out, and I'm sure thrashed out it will be. So on that note, I'm going to say bye-bye, YouTubers.